Blessings to all. Welcome to Facts, Not Fiction. I'm your host, Victor Roberts. Join me Thursday the 8th at 7:30 p.m. sharp. Yes, 7:30 p.m. sharp. As we discuss government cover-up in Petrotrin fake oil scandal. This Thursday, ladies and gentlemen, as we discuss facts, no fiction, I'm out. Blessing, good afternoon to each and every one. I want to say welcome to Facts, Not Fiction, and we welcome you locally, regionally, and internationally. Of course, as promised, last Thursday I pledged to continue to bring you information in relation to this oil scandal and the cover-up by our administration, those who have the authority of governance in our country. And today is no different. So thus far we have, on last week we looked at Finance Minister Colin Mburt, who chairs the JSC on energy and energy affairs. We looked at for almost 2 years, throughout 2016 and 17, the chairman refused to convene, refused to call together that committee to deal with energy issues simply because that committee would have exposed certain information in relation to the fake oil scandal. And of course, we also know for a fact that based on an email that is allegedly sent by foreign energy consultant Gaffney Klein and Associates to Petrotrin, suggesting that Petrotrin did not give that entity the correct figures in relation to the investigation. And of course, we will continue to ask the question as to if this email is true, where did Gaffney and Klein's associate get the correct figures to determine that the information, the figures that came from the audit was not accurate. And therefore, we are also calling on Kroll's Auditing of Canada to also help us to clarify if what this Gaffney and Klein is saying, according to the alleged email, if there is any form of truth to it. Because of course we know that both of them get the information from the same source. And if the source that brought the information was not accurate, then Gaffney and Klein Associates must tell us where did they obtain the correct figures from. So we also looked at 4 government members on a joint select committee dealing with state enterprise refused to support a hearing on this fake oil scandal. Refused to support a hearing on this fake oil issue. And of course, we also had the deceased minister, Franklin Kahn, who sought to distance the government, as we recap, distance the government from the audit and also distance the government from the individuals involved. But we know for a fact that you cannot separate Keith Rowley from his friend. We know for a fact that you cannot separate the friend of the boasting prime minister from each other. A matter of fact, information coming out of the call by the Prime Minister, he states clearly that every drilling is his friend. It is his partner. They are friends. And he went on to say that, look, if you are to hear such about a friend of yours, won't you call to find out if what I'm hearing is true? So, ladies and gentlemen, we also looked at the Prime Minister blunder, even while an investigation was ongoing, an investigation which was taking place with his friend. He didn't see it fit to call the same Minister of Energy who sought to distance the government from the audit and who sought to distance the government from those involved. He did not see it fit to call his Attorney General. He didn't see it fit to call the chairman who he appointed. He did not see it fit to call the members of the board that he also appointed. He did not see it fit to inquire from the Commissioner of Police, but he saw it fit to call the main subject in this fake oil scandal, his friend A&V Julin. And now, ladies and gentlemen, we had reached the part where our research show us where a letter was sent to the Petrotrin board. And this information states, by letter dated the 13th of June 2016, in reply to A&V letter on the 18th of April, some 2 months after 2016, Petrotrin said that its board of directors had approved by instruction. The board of directors had approved by instruction a series of revisions to the IPSC. We are still waiting to understand who gave the board that instruction. So while, ladies and gentlemen, they made those amendments to the IPSC, we see that although they did not commit themselves to renewing the IPSC for a further 10 years, as had been requested by A&V, we recognize that the revision of the IPSC went 5 years beyond the term of A&V contract. What is that telling us? It is telling us that the amendments that the board of Petrotrin made by instructions, even though they did not sign and renew the contract for the 10 years which A&V was seeking in all of this, but yet because of the variation to the IPLCs, ladies and gentlemen, it extended the contract of AV by 5 years, ladies and gentlemen. Ladies and gentlemen, as we examine the validity of this, as we examine, ladies and gentlemen, to see if what the board had done was in fact legal, we recognize that the job offer letter has a lot of merit in it. Let me read something for you all. The job offer letter may be in the form of a letter on the company's or employer's official letterhead, which is signed and sealed by the company stamp. This letter may be sent to the prospective employee by regular mail, hand delivery, by fax, by social media, such as WhatsApp, Facebook, or it may be in the form of an email sent from the employer official email and electronically signed, or signed by the head of human resources department or by the company's general manager or any person who has the task of selecting and appointing employees. All those modern means are legal. You understand what is happening here? All those means are binding. So what we are trying to understand, ladies and gentlemen, is based on this letter that Petrotrin Board sent to A&V Drilling, which of course will be on a Petrotrin letterhead, which of course will be fixed with the Petrotrin stamp. It tells us that because of the amendments that they made to the IPSC, even though they did not sign the dotted lines in relation to the extension of the contract that A&V was soliciting, yet to the end of the day, this document which they signed, which includes the amendment to that contract for a further 5 years beyond the date of the expiry date of the contract that was in his hand, it is indeed, in fact, legal. But let's just go a little further and look at labor regulation. In the labor regulation, ladies and gentlemen, contract of employment relationship. This document states a contract of employment in Trinidad and Tobago may be oral or written, express or implied. Common law is applied by the industrial court when determining the question of whether a contract of or a contract for service exists between a person and an employer. When determining this question, the court may consider, in addition to the control test, the organizational test, and the economic reality test. So it's giving us an idea as to what the court will do to determine whether or not a contract for employment is binding, whether or not it is signed, whether it is implied, whether it is written, or whether it is expressed. It said these tests, enunciated by McKenna J. in the English case of Ready Mix Concrete, Southeast Limited versus Minister of Pension and National Insurance, 1986, folder 2QB 497 of 1986. 1 ALL ER 43 has been approved and applied by the industrial court when determining whether a contract of or for service exists. For example, in the IRO 10 through 13 ETAL of 1989 and Transport and Industrial Workers Union and Neil and Marcy Limited, 1994, it is a question of fact in each case, and that the court will go beyond any written contract to determine the true nature of the relationship. Contract of employment. Ladies and gentlemen, the citizens of Trinidad and Tobago, we need to find out, we need to have a major investigation into this major conspiracy by this government to cover up this fake oil scandal, where for a fact we know that there were many high-ranking government officials who were and who are involved in this discrepancy in relation to the closure of Petrotrin. Ladies and gentlemen, I want to suggest to you today, I want to suggest to you tonight, ladies and gentlemen, that this was a holistic plan, a plan by many players, a plan which entails many officials who was, and who is going to benefit if we allow, ladies and gentlemen, what is happening in relation to this investigation to go under the carpet without a serious investigation. When you have, ladies and gentlemen, a candidate who was handpicked and screened by the Prime Minister of this country, when you have an individual that a Prime Minister boasts it is his personal friend, when you had a Minister of Energy who withdrew himself from a legal audit, an audit to determine if there were any misconduct, if there were any form of corruption, if there were any misgivings in relation to a state-owned company, a company which was the backbone of the economy of this country, a company that provide forex, a company that provide taxes, a company that provide all forms of revenue, a company that brought employment to thousands upon thousands of citizens, a company that by extension all service companies, all businesses survived and benefit as a result of this state-owned company that we call Petrotrin. A company that was sabotaged by government. A company that government reaped the benefit. A company that government placed corrupt officials in strategic places where their friends and their financiers could benefit from wrongdoing. A company, ladies and gentlemen, that stood tall throughout the Caribbean and this part of the hemisphere. A company that helped Caribbean countries. A company that helped communities. a company that was a major provider. This company, ladies and gentlemen, was sabotaged by this administration, and therefore we as citizens, we must not allow, we cannot allow this type of behavior to succeed. Ladies and gentlemen, every drilling lose in the High Court. Every drilling lose in the Appeal Court. The Privy Council, ladies and gentlemen, refused to entertain simply because there were no evidence or facts to allow a hearing in the Privy Council as far as this oil scandal was concerned. None whatsoever. And yet, to the end of the day, ladies and gentlemen, we have now found ourselves in the hands of some shotgun abattoirs who every drilling had the responsibility to choose one who Rowley Friend, an appointed chairman of Petrotrin, Rowley personal lawyer, had the opportunity on behalf of Petrotrin to choose another one. And then, ladies and gentlemen, they all get together and choose the third one. Therefore, my question to you, ladies and gentlemen, is that did Petrotrin receive natural justice out of this situation? Did Petrotrin receive natural justice? Ladies and gentlemen, let me share something with you. Let me share something with you, ladies and gentlemen. And you must decide if natural justice, Petrotrin were able to receive coming out of this arbitration. Section 6.1 states, ladies and gentlemen, natural justice implies fairness, reasonableness, equality, and equity. Article 14 and 21 of the Constitution provides the strong basis of the principle of natural justice. Article 14 bars arbitrary action, whereas Article 21 provide for listen me carefully. Article 21, ladies and gentlemen, provide for substantive procedural fairness in matters which affects the life and liberty of individuals. Ladies and gentlemen, it says that this article must have procedural fairness in matters which affect the life and liberty of individuals. Section 3 says, two main principles of natural justice are: one, no one should be the judge in his or her own case, and two, each party should be given the opportunity to be heard? Was Petrochin given the opportunity to be heard, ladies and gentlemen, in this whole arbitration situation? Article 631 states, rules of fairness. Rules of fairness, ladies and gentlemen. Hear what it says. Rule of fair hearing simply implies that a person must be given an opportunity to defend himself. Must be given an opportunity to defend himself. Ladies and gentlemen, did Petrochin receive that opportunity to defend itself before these arbiters? Was the Petrochin auditors able to come and testify on behalf of Petrochin? Was Bisesa and Rajkumar, were they able to come before the tribunal and testify on behalf of Petrochin? Was these individuals summoned to the tribunal where they could have stayed and give the accurate account of how they determined something was wrong, why they had to do that internal audit, and based on the findings of that internal audit, they had to invite 2 other international forensic audits to look into the affairs, whereby the accurate figures would have been able to be placed on record in defense of Petrochin. Was natural justice served in relation to Petrochin? Ladies and gentlemen, added to that, we continue at senior attorney for Petrochin asked the government to make the necessary adjustments and move to have the findings, to have the decision of these arbiters set aside. To date, ladies and gentlemen, why is Faris Alwari not making the necessary move public so that public confidence can be restored that the government, they are making moves to have this judgment set aside? Ladies and gentlemen, we have case law to prove that it can happen. In the Court of Appeal, the Court of Appeal has given attorney representing Petrochin a second chance to challenge a 74 million arbitration award. Appellate Judge Peter Rajkumar and James Aboud recently held Petrochin appeal against a judge's decision to reject its application to set aside the arbitration award pending the determination of its challenge against it. Last year, Pioneer Construction received 2 awards by arbitration against the former state company Petrochin. Pioneer Construction sought to enforce the arbitration order before Justice Ricky Rahim, but Petrochin countered by applying under the Arbitration Act to have the order set aside and a stay pending legal challenge. Why is not this government making the necessary move to have this arbitration set aside, that arbitration judgment set aside, in order to give Petrochin necessary legal authority to contest this judgment. Ladies and gentlemen, is it a case where government officials is waiting patiently to collect the share of the pie from the evidence in relation to this investigation, even by the way of letter that the board of Petrochin sent to A&V? Ladies and gentlemen, our citizens of this country could well have to pay beyond $1 billion in settlement to A&V drilling. I am yet to understand how come a company could win in the High Court, a company win in the Appeal Court. The Privy Council had no time because of a lack of evidence to hear the matter and lost before some arbitration, some arbiters that arbitrate on behalf of who? Was these arbiters arbitrating in a decision to bring forth a verdict on one part of this? Or is it, ladies and gentlemen, that everybody is simply looking for the share of the pie? That is what we need to find out. Ladies and gentlemen, as we warm this thing up, this ain't nothing new in this country, ladies and gentlemen. The PNM accustomed covering the tracks of all their corrupt activities. This is nothing new. The PNM accustomed, ladies and gentlemen, putting a wet blanket on top of their tracks so that to the end of the day, they take care of their own. This ain't nothing new to us. Remember in 2005, Petrochin and the World GTL plan. You remember that joint venture, ladies and gentlemen? That joint venture that cost the company about $2.7 billion to build this plan in Trinidad. A plan where they were saying that they were going to bring natural gas, more ozone layer friendly, and turning it into liquefied diesel. You remember that, ladies and gentlemen? Ladies and gentlemen, you remember that out of that situation, ex-President Malcolm Jones was found to be in breach of his fiduciary duties. He was found in breach of his fiduciary duties, ladies and gentlemen. What is this duty? This duty, ladies and gentlemen, is where persons, directors, or boards will look at the best interests of the client rather than looking after the interests of themselves. This duty, ladies and gentlemen, this fiduciary duty, there is three major responsibility that goes with it. One, a duty of care. Two, a duty of loyalty. And three, a duty of obedience as maintained by state and common law. And when the then government, the People's Partnership Government, back in 2011, found out that there was a breach in this regard, they took the necessary steps. The necessary steps, ladies and gentlemen, will show where Malcolm Jones were before the court, where if lost, that case would have had to pay not only 79 million US back to this country, but also legal fees. But ladies and gentlemen, when all that was happening, we see a gentleman, a Queen's Counsel by the name of Nelson, who gave advice to the sitting government. And this advice, ladies and gentlemen, was that there is a reasonable likelihood that a judge will be persuaded that there was a bad business deal, but no negligence on Malcolm Jones' behalf. Added to that, ladies and gentlemen, but during the hearing of the appeal by the board questioning why exactly would the state discontinue a US $97 million lawsuit based on only just one paragraph of legal advice by this gentleman on the screen. One paragraph of legal advice by this gentleman. This same gentleman, ladies and gentlemen, you will understand on another life why some of these information were put in place not only for Malcolm Jones' issue, but for another issue, for another life. Ladies and gentlemen, the Privy Council Board, comprised of Lord Wilson, Hodge, Andre, Kitchen, and Seals, stated a significant public interest was attached to the case and disclosure should be made by the state to secure transparency and accountability in relation to the decision. Ladies and gentlemen, while all this was taking place, the PNM had prepared to take care of their own. While all this was taking place, ladies and gentlemen, it was pointed out that on October 8, 2015, the same Malcolm Jones was appointed by the ruling PNM government to a cabinet standing committee on energy, and that it was also on October 8th and 9th that the Minister of Communication stated that the case against Jones was heading in the direction of being dropped. Malcolm Jones, while being in court, while having to answer for negligence of his duty, while that matter was going on, ladies and gentlemen, the Keith Rowley administration saw it fit to appoint the same Malcolm Jones on a standing committee on energy in our Parliament of Trinidad and Tobago. That is how clever the PNM does its job. When the PNM want to cover up, ladies and gentlemen, they cover up with a sheet, a blanket, or anything available to cover the sin of corruption. But not only they use a blanket or a sheet to cover their corruption, but they lie, blatantly lie, to cover their corruption. Ladies and gentlemen, I want you to understand quite clearly, on the 7th of June, 2019, the Attorney General Faris Al-Wari said he has obtained the statements in the statement related to the Malcolm Jones case. He was responding to a question from Naparima MP Rodney Charles on why the government was not fulfilling the May 23rd promise by the Prime Minister to release the documents relating to the state's decision to drop its multi-million-dollar lawsuit against former Petrotrin Executive Chairman Malcolm Jones. Brother Archie, if you have the Attorney General picture, put him up there. I want to see him. Put him up on the screen. I want Trinidad and Tobago to see the Attorney General picture before I go on. Put him up on the screen. Watch how he dress nice. Watch how he keep himself neat. And watch what coming out of his mouth. The Attorney General, I want you to notice something, Trinidad and Tobago. I want you to notice the man. And when you notice the man, I want you to judge for yourself if you would have expected these words to come out Faris Al-Wari mouth. A matter of fact, not only come out Faris Al-Wari mouth, but come out his mouth under oath in our parliament. A place, ladies and gentlemen, that the government continue to desecrate, not only by the speaker conduct, not only by the Prime Minister conduct, but by the conduct of the members of government that sits in the parliament. Watch Faris Al-Wari. Watch how neat. Watch how handsome. Watch how this man dress. And tell me if you would expect something like this to come out a man mouth, but the word really tells us that looks are deceiving. So when Rodney Charles asked the question, I want to read it again. He was responding to a question yesterday from Naparima MP Rodney Charles on why government had not fulfilled the May 23rd promise by the Prime Minister to release document related to the state's decision to drop its multi-million-dollar lawsuit against former Petrotrin Executive Chairman Malcolm Jones. Mr. Faris Al-Wari, our Attorney General, hear what he said. He told Rodney Charles and the Parliament, the state took no decision to end Malcolm Jones' matter. Ladies and gentlemen, I am quoting Faris Al-Wari words. Faris said, the state took no decision to end Malcolm Jones' matter. The company Petrotrin did. Ladies and gentlemen, on March 4th, 2016, on March 4th, 2016, Prime Minister Rowley yesterday defended the decision by the government to discontinue a lawsuit brought by the previous administration against former Petrotrin chairman Malcolm Jones. Faris Alwari, the state took no decision to end Malcolm Jones' case. Keith Rowley, the government of Trinidad and Tobago, they took a decision to discontinue the lawsuit brought by the former administration. Ladies and gentlemen, who is the liar there? You judge. Who is the liar here? Pharisee, state didn't do it. Rowley say he defended the state's decision to discontinue the matter. What I am saying to you, ladies and gentlemen, the cover-up ain't nothing strange with this PNM administration. The lies ain't nothing strange with this administration. The Prime Minister, ladies and gentlemen, the Prime Minister said that he will defend the government position in defending the government position in the withdrawal of Malcolm Jones' case. Ladies and gentlemen, when you remember that scenario quite clearly, there was a matter between Maraj and the state when he was looking, ladies and gentlemen, for the information, the statements to be made public on the whole Malcolm Jones fiasco. It went all the way to the Privy Council. When he won the matter at the Privy Council, ladies and gentlemen, Faris Alwari came back and brought an amendment to the Freedom of Information Act, brought an amendment to protect and to hide certain information that the public have to go through a rigorous form to get that information in the public domain. Ladies and gentlemen, this government is not a government of the people. This government is not a government for the people. While this government may not even be a government by the people. And for me saying that, ladies and gentlemen, we could never have fair elections in this country when you have the niece of a former sitting member of parliament, of cabinet, a hierarchy in the PNM managing the affairs of the EBC. You could never get justice. These institutions is what should be independent. But nevertheless, ladies and gentlemen, coming back to this story, we await the conclusion of this investigation by the police. We await patiently the outcome of this investigation into the fake oil scandal by the TTPS. We await. Ladies and gentlemen, last week also, I was on the point of Ansel Roger and the OWTU, who met with government officials in the name of Stuart Young, Keith Rowley, Camille Robinson Regis on the 13th of February 2017. Ladies and gentlemen, I also hear Anel Roberts said on the program that Friday he wants to deal with Roger. So what I intend to do, I intend to stick on my part what I was dealing with him with. Ansel Roger, you had the opportunity to put 2 of the OWTU members on the 7-man committee that Rowley indicate will do a review of Petrochin with an aim to restructure, and within 3 weeks they will report to the cabinet. You was part of that discussion, Roger. You also, Roger, know for a fact that not only the restructuring of the workers of Petrochin was coming, but you know that the government intention was to close the refinery. You also know, Roger, that there was discussion between you and the government in order to get the refinery. Roger, my question remains. Roger, are you now satisfied, seeing that the government have now betrayed you? Are you satisfied with the fight that you put up for the Petrochin workers? Are you satisfied, Roger? Now that you have been betrayed by a team that sit with you, probably eat with you, probably drink with you, and then turn around and saw off the OWTU head from its body. The most powerful union in Trinidad and Tobago now resort to be the worst union that this country has ever seen. I could only imagine the way the spirit of Butler felt as a result of what happened to that trade union movement in which Butler was the founding father, a fighter, a deliverer, a man who stand for the people, a man who fight for the people, a man who went through many battles for the people, a man who was wanted dead or alive for the people. I could imagine how Butler spirit is now feeling as a result of what the trade union, the OWTU, has now resort to, ladies and gentlemen. Ladies and gentlemen, the OWTU failed the people of this country. The OWTU failed Petrochin workers. Why they failed Petrochin workers? Was it because of a promise? Was it because that the OWTU name would have been over the railing and point up here? Was it because of that the OWTU failed the workers? The OWTU, ladies and gentlemen, fighting to hold on to a straw. Fighting. I don't know if Comrade Roger had ever understand what is meant by a promise is a comfort to a fool. Rowley has made the OWTU the biggest fool in Trinidad and Tobago, especially before the 2020 election, a matter of days. The call for the OWTU to come and sign. We are ready to deliver. We are ready to deliver. But the OWTU didn't understand that that baby was breached. They didn't understand that it didn't have no deliverance for that baby. They didn't know that the baby was about to be killed. And that is what happened to the OWTU. That is what happened to the OWTU. Petrotrain workers now suffering. Petrotrain workers lining up to get a hamper, a mingy hamper that this government said they give it out. Petrotrain workers texting and asking for help. Some of Petrotrain workers hiding the vehicles from bank and other financial institution. Petrotrain workers, some of them lose their house. Petrotrain workers, some of them commit suicide, ladies and gentlemen, because of a failed union who fail to stand up with fortitude and fight for the people. A union who fail to help those who have been paying contributions in the form of union dues for years, putting the union in a financial stable way. To the end of the day, these people's hearts were broken by the decision of the trade union who say they represent them. That is a fact, ladies and gentlemen. That is a fact. And that is why I am saying that the OWTU needs to remove their President General from office. Just as how the citizens of this country need to remove Keith Rowley from office, in the same breath and the same manner, let us send Rowley and the president of the OWTU down to Haiti for holidays. Send them down to Haiti for holidays. That is a good place for them to be, because you cannot tell me that the hardship that the union allowed to befall the people that support the union, it is a shame to see what is happening with these same people who lost the medical, lost the benefit. They fighting in the hospital to get numbers, to see about the ailment, when they were paying a pension plan, when they were paying medical for years, catering for when they reach this age, where everybody know as you age, sickness will come. They pay that pension and that medical for years, so that in this time of need, they can be able to have proper and the best health care. Today, all that going down the drain because of the failure of the OWTU. Ladies and gentlemen, as I wrap up, I want to say something tonight. I want you, ladies and gentlemen, to understand something here tonight. Ladies and gentlemen, members of my party, I want you to understand tonight. If
Those
you
who have lost
never
their jobs,
understand before,
lost all their savings, what about them?
I want you to understand.
I call upon the government
that
again, please.
Loyalty have no figure attached to it. I want you to understand, ladies and gentlemen, that no amount of money could pay for loyalty. Loyalty have no figures attached to it. And once you allow your loyalty to be bought, you could have your loyalty bought for 3 million and then have it sold for $3. I want to repeat that. I want you to understand that loyalty have no figure attached to it. And once your loyalty is up for sale, it can be bought for $3 million, and then it can be sold for $3. I want you to take that in good, in your good head, if you have that, to understand, ladies and gentlemen, that the UNC is bigger than all of us. Before Victor Roberts was the UNC, and after Victor Roberts, where we made the UNC. I will say it again. Before Victor Roberts was the UNC, and after Victor Roberts, where we made the UNC. None of us is bigger than this party. None of us is bigger than this party. None of us is bigger than this party. And if you feel that you're bigger than this party, and if you feel that the party cannot do without you, then think again. Loyalty have no price attached to it. Loyalty have no money attached to it. Ladies and gentlemen, loyalty have no money attached to it. I want to pong it in your skull that you could understand. I want to be pong, not physically, with words, so you could understand that this party, this UNC party, have some loyal soldiers. And I'm talking about real loyal soldiers. Soldiers who loyal to the leader, and whenever the leader take her leave, going to be loyal to whoever the next leader that the party elected. All you hear what I said here this evening? Going to be loyal to the next leader that the party choose. So all who feel that they have a problem with Kamla Prasad Bisesa, and all who feel that they could give Kamla Prasad Bisesa pressure to leave the party, then go and drink a good and juice. I'm out.